14th District Court for County of Washington, State of Michigan is now in session. Those having business before the court are near, the Honorable Judge J. Simpson presiding.
You may be seated. And Ann told you didn't have to stand. Anyway, court does call the case of the People versus Simpson win.
Good morning, Your Honor. Patricia Reiser of the People.
Good morning, Your Honor. James sIg5Vha6SwM appearing with and on behalf of Mr. Wynn, who's to my right.
All right. Are there any preliminary matters we need to take care of before we begin selection? I think all of the pretrial motions and everything have been decided.
I believe so. I'm not aware of anything else at this point to discuss.
I am of the impression that they've already decided. I would ask the court, I don't get picked a jury with you before, and I just wondering the general procedure.
General procedure is that I think it's a pretty standard procedure, at least my standard procedure. We will be bringing our panel in, pick out those 7. I will ask each round whether or not you have a challenge for cause, even though you may not have exercised or tried to exercise one before, as well as preemptories. When we're all set, we're all set. In terms of all questioning, I allow attorneys, it's your case, to do the questioning. I do not allow jurors to be picked on, so you can ask the general question and then hone in on a juror if they, depending on how they respond. But I don't like a juror being picked out for a particular question. All right?
Did that have any juror questionnaires yet, or do those come when they're brought in?
You don't have the questionnaires.
No.
Those come from Paul.
Should have had those down. I should have a set. So you gotta get her. I'm out. I gotta bounce.
And did the court have any potential dates for the actual trial? We'll get to that later.
Yeah, I'm gonna do it on a Saturday. I 23rd and 25th.
All right, so the 23rd and the 23rd Monday is the trial. So we
You can do the 23rd or the 25th. You want it in the afternoon, or how do you want that?
I'm sorry, are there any later dates? I had brought this up at Final Settlement Conference, just to have a little bit more time to get up to speed on everything.
Oh, riser. Yeah, we've got later dates. I don't know what they are, but I'm sure we do.
So we could do Tuesday the 14th at 1 p.m.
November. Tuesday the 14th.
At 1 p.m. It works for me.
I mean, I don't,
Might be.
I don't-
another date after that though.
why?
I think at least from.
How many witnesses are you anticipating? I mean,
Yeah, I just think that maybe the complaining witness and most likely my client will take quite a while. I've got 3 additional witnesses, but they're pretty minimal, as I think the court is aware. But because there could be some,
give me a morning start. Just go.
I think we can do it in a day. I just don't think we can in an afternoon.
Oh, I think we can.
So Monday, November 13th, we can start at 9 a.m. We have a deep docket.
We can move or break.
Mhm.
Okay. The November 13th then.
It's good for me.
So questionnaires are supposed to be requested ahead of time. Admin just needs to look at it and they will work on them and they can bring them in for us.
Should be requested by who?
She said the attorneys are supposed to ask beforehand, they're supposed to ask by the Wednesday before selection. And I said,
Who makes these?
I don't know.
Just making a rule. Making a rule, that's not a rule. Your questionnaires will be down shortly.
Thank you, Judge.
I'm saying that, I'm not doing it, but we hope that they'll get down here. Okay, so what's happening? Am I off now?
No.
We're live. All right. The court does call the case of the People's State of Michigan versus Simpson Win. Counsel, if you could state your appearances for the record again, please.
Good morning, Your Honor. Patricia Reiser on behalf of the people.
Good morning, Your Honor. James Fifelski appearing with and on behalf of Samson Wynn, who is to my right.
All right, very good. We have gone through some preliminary matters, and I think we have everything straight. Although there are two cases, we will be reading it as one complaint and calling only one case. All pretrial motions, as I had indicated before we left the record, have been decided. The parties will be guided by that. Parties also now do have the jury questionnaires, have had a brief opportunity to review them, and we are ready.
Yes, Your Honor.
Yes, Your Honor.
All right. Need the jury. Can Alexis bring them down for us?
I don't care.
Oh, got it. Got it.
Right, I'll be right back.
And counsel, just so that you're aware, after CGI 1.7 regarding health questions, which really has been taken care of at this point, that is when I put the 7 in the box and then proceed from there, so that you know.
Okay.
Okay.
To the jurors getting here, there is one juror who we know has a conflict on the date we selected, and so we will be skipping that juror it's one of the jurors that's coming in, but we will be skipping that juror.
Okay.
Got one more. And good morning, ladies and gentlemen. Y'all set. Court does call the case of the people of the state of Michigan versus Simpson Wind. Counsel, please state your appearances for the record.
Good morning, Your Honor. Patricia Reiser on behalf of the people.
Good morning, Your Honor. James sIg5Vha6SwM appearing with and on behalf of Simpson Wind.
All right, thank you. Ladies and gentlemen, I'm Judge J. Cedric Simpson, and it's my pleasure and privilege to welcome you to the 14A District Court for the County of Washtenaw. I know that jury duty may be a new experience for some of you. Jury duty is one of the most serious duties members of a free society are asked to perform. Our system of self-government could not exist without it. A jury is an important part of this court. The right to a jury trial is an ancient tradition and part of our heritage. The law says that both the person who is accused of a crime and the prosecution have a right to a trial not by one person, but by a jury of impartial persons. Jurors must be free as humanly possible from bias, prejudice, or sympathy for either side. Each side in a trial is entitled to jurors who can keep an open mind until the time comes to decide the case. A trial begins with jury selection. The purpose of this process is to obtain information about you that will help us choose a fair and impartial jury to hear this case. During jury selection, the lawyers, and sometimes I, will ask you questions. This is called voir dire. The questions are not meant to find out, the questions are meant to find out if you know anything about the case. Also, we need to know and find out if you have any opinions or personal experiences that might influence you for or against the prosecution, the defendant, or any of the witnesses. One or more of these things could cause you to be excused in a particular case, even though you might otherwise be qualified to serve as a juror. The questions may probe deeply into your attitudes, beliefs, and experiences. They are not meant to be an unreasonable prying into your personal lives. The law requires we get this information so that an impartial jury may be chosen. If you do not hear or understand a question, you should say so. If you do understand it, you should answer it truthfully and completely. Please do not hesitate to speak freely about anything you believe that we should know. During the jury selection process, you may be excused from serving on a jury in one of two ways. First, I may excuse you for cause. That is, I may decide that there is a valid reason why you cannot or should not serve as a juror in this case. Or, a lawyer from one side or the other may excuse you without giving any reason for doing so. This is called a peremptory challenge. The law gives each side the right to excuse a certain number of jurors in this way. If you are excused, please do not feel bad or take it personally. As I have explained before, there simply may be something that causes you to be excused from this particular case. I will now ask all of you to stand if you can, and to swear to answer truthfully, honestly, and fully all of the questions that you will be asked about your qualifications to serve as a juror in this case. If you would please raise your right hands. If you do have religious beliefs, ladies and gentlemen, against taking an oath, you may instead affirm to answer all of the questions truthfully, honestly, and fully. Here is your oath. Repeat after me. I do solemnly swear that I will truthfully and completely answer all of the questions about my qualifications to serve as a juror in this case. Thank you, ladies and gentlemen. We may be seated. Now, my favorite part of jury selection now comes. I'd like to introduce members of my staff and those that get me going each day and make sure I'm in the right place that I should be, at least most of the time. All right. Immediately to my right is Corporal Allen. He is actually with the Washington County Sheriff's Department. He is my bailiff. Mr. Allen is responsible primarily for my security, but while you are serving as jurors, he is also responsible for your security. Seated immediately to my left is Ann Weidling. She has received a recent promotion. She was my court recorder about a week ago. She is now my judicial coordinator. She has been promoted to that, and so every day she is the one that is actually responsible for making sure that I'm where I'm supposed to be. She got me here today, so I guess she's doing a good job. Thank you, Ms. White. As she is recording today, and just so that you know, she's responsible for making sure that everything that happens in the courtroom is taken down and if necessary afterwards transcribing the proceedings. Seated to her right is an individual that we go way back, and that's Kristen Serrano, who is, and I say we go way back, actually we met today. And she is, if I am so lucky, might be serving as an intern with myself and helping me with some of the legal work that I have to do. Ms. Serrano, thank you. All right. Ladies and gentlemen, this is a criminal case involving the charge of aggravated domestic violence and domestic violence, which I will explain more fully later. The charge has been made against the defendant, in this case, Simpson Wynn, and the defendant's lawyer is Mr. Fifowski. Mr. Fifowski, if you could please introduce your client again, and please list members of your office and anyone you intend to call in this.
Absolutely. Thank you, Judge. Hello, I'm James Fifowski, and I'm representing Simpson Wynn to my left here. I'm a solo practice attorney in Ann Arbor, so I don't have any other attorneys working with me. Nobody to list out there. The individuals that I will most likely be calling as witnesses in this case are my client, Simpson Wynn, Isaac Perez, Connor Zabrowski, Alexander Morris, and potentially Pittsfield Police Officer Rosaria Gonzalez.
Thank you. Before I get to the other side, does anyone seated in the jury panel know any of the individuals as listed by the defense? If you do, please raise your hand. The record should reflect that there are no hands raised. Lawyer for the state of Michigan is Assistant Prosecuting Attorney Patricia Reiser. Ms. Reiser, if you could please introduce yourself to the jury, list members of your office, and list any potential witnesses you intend to call.
Thank you, Your Honor. Good morning, everyone. My name is Patricia Reiser. I work in the Washington County Prosecutor's Office. I have a number of colleagues that also work here. I'll just read the list so I don't miss anybody. The elected prosecutor is Ellie Savitz. The chief assistant prosecutor is Victoria Burton Harris. Other people in the other prosecutors in the office are Nimish Ganatra, Morgan Barroso, Jessica Blanche, Kyle Burdell, Grace Broughton, Lou Danner, John Emmons, Nicole Hughes, Caitlin Kirby, Ashley Lundy, Rachel McDuffie, Amy Reiser, Allison Robbins, Laura Willenbring, Todd Pierce Ryan. Additionally, we have Stacy Shaw, Rob Dowd, Darren Miller, Jennifer Tink, Christina Hines, Gabriel O'Connor, and Marie Tiana. Those are the people in my office that work as attorneys. Possible witnesses in this case would be Kelly Loggins, also Officer Rosaria Gonzalez from Field Township Police Department, and Officer Glenn Blaha from the Field Township Police Department. Thank you.
Thank you, Ms. Reiser. Does anyone seated in the jury panel know any of the individuals as listed by the people? If you do, please raise your hand. And the record should reflect we have no hands raised. Ladies and gentlemen, we think that this trial will last for 1 day. For any of you, and I know that you've been asked this and it has been disclosed. Are there any health problems that you have not disclosed that would prevent you from serving on the jury? For example, does anyone have a medical problem that makes them unable to sit for 2 or 3 hours at a time? Or does anyone have a sight or hearing problem? If you have not disclosed it, if you could please raise your hand if that is the case. Record should reflect that there are no hands raised. Ms. Wadling, may I have 7 jurors?
Lindsay Clark, juror number 6, if you could please stand and have a seat in seat 1.
Don't look so surprised. Just come on. She looked absolutely.
I didn't get my coffee this morning, so.
Okay, you're good.
Eileen Young, juror number 78, if you could please stand and have a seat in seat 2.
In the back. I'm sorry. Yeah, back.
Mr. Ronald Zane, number 79, if you could please rise and have a seat in seat 3. Ms. Rachel Watson, juror number 74, if you could please rise and have a seat in seat 4. Mr. Matthew Tenery, number 69, if you could please rise and have a seat in seat 5. Ms. Diane Molesky, juror number 43, if you could please have a seat in seat 6. And Mr. Nepal Ramatar, juror number 54, if you could have a seat in seat 7.
And I'd ask all of you to remaining out there to listen to the questions and to continue to listen to the instructions of the court. Ladies and gentlemen, this is a criminal case. The paper used to charge the defendant with the crime in this case is called the complaint. The complaint in this case charges the defendant, Simpson, with the crimes of domestic violence and aggravated domestic violence, and it reads as follows. That between the dates of April 30th, 2021 and August 31st, 2021, at the location of 4832 Washtenaw Avenue, apartment C8, Pittsfield Township, Washtenaw County, state of Michigan, that the defendant did assault a Kaylee Loggins, an individual with whom he had a dating relationship without a weapon, and did inflict serious or aggravated injury upon her, but without intending to commit the crime of murder or to inflict great bodily harm less than murder, contrary to Michigan statutes. That is count 1. Count 2 alleges the offense of domestic violence and reads as follows, that between the same dates at the same location in Pittsfield Township, Washtenaw County, state of Michigan, that the defendant did make an assault or an assault and battery upon a Kaylee Loggins, an individual with whom he had a dating relationship contrary to Michigan statutes. Count 3 alleges that between those same dates at that same location in Pittsfield Township, Washtenaw County, state of Michigan, it alleges that the defendant did commit an assault or an assault and battery upon a Kaylee Loggins, an individual with whom he had a dating relationship contrary to Michigan statute. Count 4 alleges that on or between those same dates at that same location in Pittsfield Township, Washtenaw County, state of Michigan, that the defendant did make an assault or an assault and battery upon a Kaylee Loggins, a resident or former resident of his household, or an individual with whom he had a dating relationship contrary to Michigan statutes. Count 5 alleges that on or between those same dates at that same location in Pittsfield Township, Washtenaw County, state of Michigan, it alleges that the defendant did make an assault or an assault and battery upon a Kaylee Loggins, a resident or former resident of his household, or an individual with whom he had a dating relationship contrary to Michigan statutes. The defendant has pled not guilty to these charges. You should clearly understand that the complaint I have just read is not evidence. A complaint is read in every criminal trial so that the defendant and jury can hear the charges. You must not think of it as evidence or that he is guilty because he has been charged with these offenses or even one offense. Person accused of a crime is presumed to be innocent. This means that you start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty, unless and until you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Mr. Reiser, voir dire.
Good morning again, everyone. I am going to just ask a series of questions, and if anybody has anything to say about what I'm asking, just please raise your hand. If there's something you want to say that you don't want to say in front of the whole group, let us know that, and we can talk privately. This is the most awkward question, so I'll just get it out of the way. Does anyone have any convictions? And I'm not talking about traffic tickets, but just any convictions. Okay, no hands are raised. Does anyone have a philosophical or religious belief against sitting in judgment of another person? In other words, do you have a religious belief or a philosophical belief that would prevent you from deciding whether or not someone is guilty or not guilty? Okay, no hands are raised. As the judge just indicated, the charges here are domestic violence. And I'm wondering if anyone on the panel has someone that they're close to that has had a domestic violence situation that they're aware of. If so, please raise your hand. Okay. All right. 3 hands are raised. Juror in seat number 1, Ms. Clark, can you tell us about that?
Yeah, it was my best friend at the time, and it was a domestic abuse case against her with I don't really want to go into details, but I had to go and stand as a witness for that. And that was maybe about 2 or 3 years ago.
Okay. And then juror in seat number 2, Ms. Young.
My daughter was assaulted by her roommate, and I don't actually remember what the outcome was. That was maybe 5 years.
Okay. And then there was one other hand raised. I think it was the juror in seat number 7.
2 aunts and 1 cousin were involved in domestic violence situation in their marriage.
Okay, they were the victims. All right. For those of you who've had that experience or know of people that are close to you who've had that experience, would it prevent you from being fair to both sides in this case?
I would honestly say yes.
Okay.
Just because of my personal experience with what happened with that. And this is a lot of counts.
Okay.
So.
Thank you.
Just maybe.
Ma'am, and Ms. Rice, I'll let you go on. If I instructed you that you were to listen to the evidence, decide what the evidence is, and then I give you the law in the case, are you indicating to the court that you could not take those facts as you find them, the law as I give it to you, and in that way decide this case?
Maybe not as openly as I would wish to be.
And you're saying that's because of your experience? And you're saying that you could not, even given those instructions by the court, be fair and impartial to either side?
Like I said, I would not be as open as I would like to be.
Well, that's not my question. My question is that if I gave you those instructions, could you in that way decide this case?
Potentially.
Potentially. You're a lawyer. You're being very vague. All right, now, Unless there's an objection, the court is going to excuse juror number 1 for cause. From the defense.
Okay.
Any objection from the people?
No, Your Honor.
Ma'am, you are excused for cause. May I have another juror, please? No, you got to stay seated, please.
Mr. Dale Tuttle, number 70, please take a seat in seat 1.
Sir? What is your name? Yes.
William Sparrow.
Is that it?
No. Dale Tuttle.
We got rogue.
Try to stand.
All right.
Mr. Matthew Klein, juror number 31, to seat 1, please.
Good morning, sir. You've heard all of the questions that have been asked thus far. Would your responses to any of those questions be anything you think we should know? No? All right, very good. Mr. Reiser, you may continue. Let them know.
We're going to hear a lot probably from both sides in this case. You've already heard from the judge about beyond a reasonable doubt and that standard that we hold the prosecution to in this country. It's a cornerstone of our criminal justice system. I take it very seriously. I believe everybody takes it very seriously. So I just want to be clear. If I prove the case beyond a reasonable doubt, is there anyone who, for whatever reason, cannot return a guilty verdict? Anyone have any reason that would prevent them from doing that? Okay, no hands are raised. And the other side of the coin, if I don't prove the case beyond a reasonable doubt, anyone who has a problem returning a not guilty verdict for any reason? Okay, no hands are raised. Does anyone have any close friends or family, or have you yourself ever been ever worked in law enforcement? And I include in that corrections officers, people working as prosecutors or for the attorney general or anything along those lines. Okay, no hands are raised.
Officer.
Okay, that's juror in seat number 2. Your brother-in-law is a police officer?
He's retired now.
Okay, did he work in this county?
No, he worked in Florida.
Is there anything about your relationship with him that would make it so that you couldn't be fair in this case? No? Okay, thank you. Anyone else? Okay, juror in seat number 4, your brother, you said? Stepbrother, okay. Was that in this county? And would there be anything about that relationship that would make it so you can't be fair in this case? Some of you have indicated that you've had experience in your personal lives with friends or family members who have been involved in a domestic violence situation. Is there anyone who has a problem with the idea that victims look differently? In other words, that victims can come from any walk of life, any sector of the social structure, different economic situations. They can be affected differently. What I'm getting at, does anyone have a preconceived idea in their minds of how a victim, quote unquote, should look or should act? If so, please raise your hand. Okay, no hands are raised. Sort of to dovetail with that, anyone have a problem if a victim is fragile and has a support object or a support person with them? Would anybody hold that against that person if that were the case? Okay, no hands are raised. I don't have anything further, Your Honor. Thank you.
All right, thank you. Mr. Frykowski, what here?
Good morning. I'll try not to repeat any of Ms. Reiser's questions so we can kind of keep this moving. Have any of you ever served on a jury before? If so, please raise your hand. Okay. Juror in seat number 2. Do you remember how long ago that was and what the experience was like?
I think the last one was maybe 4 years ago, downtown Ann Arbor was the day.
You remember what kind of case it was?
It was theft.
Okay. So some kind of criminal charge. Do you remember what the verdict of that case was? Okay. Did you happen to be the foreperson of the jury? No. Okay. Anything about that experience that would make you lean towards one side of this case or the other, not knowing any of the facts of this particular case? Okay. Thank you. Juror in seat number 3. What was your experience?
Been a long time ago, well, I can remember about it.
Okay. Okay.
Never too, but I think we went to court or something, and they ended up selling it. We didn't have to show up again, I think. And so,
Okay. Okay. So not much that probably stands out about that could affect this. Okay. Anybody else ever served on a jury before? Okay. Thank you. No other hands are raised. Clearly there you don't know any of the evidence in this case, and so some of these questions are a little speculative, but they're important just to kind of get an understanding of your thoughts or your feelings about some of the key principles in a case like this. Judge Simpson already said that despite the fact that there are charges against Mr. Nguyen, that he's presumed innocent until proven guilty beyond a reasonable doubt. And I think in a case like this, especially where there are 5 total charges, I'll get to my question now, which is, does the simple fact that there are 5 accusations of domestic violence made against Mr. Nguyen make you think he must be guilty of a crime even before you've heard any of the evidence in this case? If so, please raise your hand. Okay, no hands are raised. And again, as Judge Simpson stated, a bedrock fundamental principle of our constitutional justice system is the presumption of innocence. And on the flip side of that I'll add and then ask you about is that a defendant, Mr. Nguyen in this case, need not present any actual evidence of innocence in order to be found innocent, because the presumption of innocence is what we start with and end with unless the prosecuting attorney proves beyond a reasonable doubt that he is in fact guilty. Are all of those standards things you can accept and abide by no matter how many charges there are in this case? If so, please raise your hand to let me know that you are willing to abide by all of those ground rules for this trial. Okay, all hands are raised. Thank you. There will be a number of different witnesses in this case, but I too expect that it should be a one-day trial, so it shouldn't go on too long. But there will be witnesses that Ms. Reiser calls to support her claim, and there'll be witnesses that we call to support Mr. Nguyen's claims. Is there any reason at all that anyone thinks they would believe the prosecuting attorney's witnesses more than the defense witnesses simply because they are testifying for the prosecution? If there's any reason at all, just raise your hand and then we'll talk about that. Okay, no hands are raised. Thank you. At some point, Judge Simpson may also instruct you that police officers as witnesses are subject to the same ways of being assessed for credibility, believability in their testimony as other non-police officer witnesses or lay witnesses. Is there any reason any of you would take every single thing that a police officer witnesses testifies to as though it's gospel truth and should not be scrutinized in any way by you as a juror. If there's any reason you would want to just basically, again, esteem a police officer's witness, a police officer's testimony without any question, please let me know by raising your hand. Thank you. No hands are raised. The charges in this case each have individual elements, and this is something Judge Simpson will explain later, but each individual charge has its own individual elements. And based on prosecuting attorney has the burden of proof for each and every one of these charges, there can be a lot of detail that we're going to go through in terms of the different dates and the different accusations that have been made against my client. Is assessing all of the particular details, including dates and different accusations that will be made in this case, something that you can agree to assess carefully and individually, or let me state this a different way. Is there anything that could prevent you from being able to really pay attention and scrutinize and assess all the evidence in this case that could make it difficult then after a day's work, basically, for you to render a just and true verdict? Is there anything that could get in the way of that? If so, please raise your hand. And no hands are raised. Thank you. Do any of you have any particular training, education, or background in medical or the treatment of injuries, anything of that nature? If so, please raise your hand. Okay, juror in seat number 2, yes. Okay. So in a case like this, and I don't think we're going to have any expert witnesses per se, but with the allegation that there was some kind of injury, are you able to put aside your own training and specialized knowledge to simply follow what Judge Simpson says about how to assess the evidence in this case? Okay, thank you. There's lots of legal drama shows and whatnot, but I guess I'll ask this question. Has anyone had a particularly bad experience personally, not just by watching TV, but personally with a prosecuting attorney, a defense attorney, a private attorney, court-appointed attorney, any attorney that then might taint your view of just how we do our work here in the courtroom as attorneys? If so, please raise your hand. Great. All right. No hands are raised. Thank you. A few more questions here. One area that Judge Simpson will instruct you about is judging credibility, the believability of an individual witness. And I think one of the things he'll tell you is that you can use your own common experience to assess whether you believe what somebody is saying or not. My question for you at this point, because there will be testimony that differs between what the prosecuting witnesses will testify to and what the defense witnesses will testify to. Can everyone acknowledge that there can be reasons for someone to lie or fabricate something, even though they believe it's true? If you believe that is at least a possibility that people can fabricate things for all sorts of different reasons, but that is a possibility, could you please raise your hand if you think that's possible? Okay, I think all hands are raised. Thank you. And would you all agree to assess each individual witness on their individual terms as an individual person, as opposed to whether they're testifying for the prosecuting attorney or for the defense? If you would agree to assess each and every witness the same way, please raise your hand. Okay, all hands are raised. Thank you. Is there anyone here who, just because Mr. Nguyen is sitting at this table and he's labeled a defendant in the legal system, and he's charged with the charges that you've heard, but there's no evidence put forward yet. You have not heard from a single witness. But do any of you think that you will just have a difficult time, if not an impossible time, of finding him not guilty if for some reason the prosecutor does not prove beyond a reasonable doubt that he committed these charges? If there's anything that you think would really just make it impossible for you to find him not guilty, please raise your hand. No hands are raised. Thank you. This is, I guess, a similar question, but I ask it all the time, just because there can be personal things in our lives that are going on, and so it can be a distraction. Is there anything in your own individual life right now that could cause you to be distracted in what I think we all agree is an important task of sitting through a trial? And if we're going to have this trial, I think November 13th, is there anything in your personal lives, and you don't have to tell me out loud, you can tell the judge, but that could really be a problem, like a sick relative or a hard time with getting laid off or something like that? If so, please raise your hand. Okay, no hands are raised. Great. I think that's it for me, Judge. Thank you. Thank you for your time.
People, challenges for cause.
None for cause, Your Honor. Thank you.
Defense, challenges for cause.
None for cause, Your Honor.
People, peremptory challenge.
Your Honor, I respectfully ask the court to thank and excuse the juror in seat number 1, Mr. Klein.
Sir, thank you. You can have a seat in the back. And have Ms. Weidling, if I could have another juror, please.
Mr. William Sparrow, number 64. Seat 1.
You okay, sir? All right. If you'd rather, Ms. Weidling, make a note, you can have a seat right in that first seat rather than trying to get yourself down that row, whichever is your preference. Sir, did you hear all of the questions that were asked?
Yes, I did.
Would your responses to any of those questions lead to anything you believe we should know?
No.
No. All right. Any additional voir dire from the people?
No, Your Honor. Thank you.
Any additional voir dire from the defense?
No, Your Honor.
All right. Defense, peremptory challenge.
Your Honor, we would like to thank and excuse Dr. Young, I believe it is, in seat 2.
We have another juror, please.
Miss Diana Kirchart, juror number 30, to seat 2.
Good morning. You heard all of the questions that were asked? Would your responses to those questions lead to anything you think we should know?
The only problem which I don't know would happen, is I failed my EKG this past Friday. I have a chemical stress test on Halloween. I don't know if anything will come out after that.
Okay,
So it is November. I'm not sure. It's an unknown.
all right, an unknown. Would that being part of your life at this point in any way distract you in this case or anything along those?
It would just be if there was testing that came up and it messed up the same day.
Got it.
Right now, no, I'm okay.
Okay, fantastic. All right. Any additional voir dire from the people?
Oh, thank you, Your Honor.
Any additional voir dire from the defense?
Very briefly, Judge. Anything about this particular case and the complaint and the charges that have been listed that causes particular challenge or concerns? Okay. Anything about assessing witnesses individually that you may find difficult in terms of the kind of accusations that have been made in this case? Okay. And just for the record, you're shaking your head no. So with the recording, that's why sometimes we just say that out loud. Okay. Thank you so much. Thank you, Judge.
All right, thank you. People challenges for cause.
None for cause, thank you, Judge.
Defense challenges for cause.
None for cause, Your Honor.
People peremptory challenge.
We have no peremptories at this time, Your Honor.
Defense peremptory challenge.
Your Honor, we would like to thank and excuse the juror in seat number 7. Mr. Ramatar, I believe it is.
Yes, sir. All right. Thank you, sir. Widling, may we have another juror, please?
Miss Jill Nordberg, juror number 51. The seat's out.
Hold in here. I saw you had your jacket on. I asked if it was cold in here and they told me it was cold. I don't feel it, so I do apologize for that. So I turned up the heat. Ma'am, did you hear all of the questions that were asked? All right. Would your responses to those questions lead to anything you think we should know?
The only thing is I am a retired nurse practitioner. That was 9 years ago. And I never worked in an ER or anything like that. It was always, I don't think there'd be anything with that, but I am a retired nurse.
All right. Okay, very good. Any additional voir dire from the people?
No, Your Honor, thank you.
Any additional voir dire from the defense?
Yes, briefly, Judge. Thank you. As a retired nurse practitioner, any past experience helping people that may have been victims of domestic violence or of assault or other injuries like that? Okay. All right. Thank you.
Thank you. Defense challenges for cause.
None for cause, Your Honor.
People challenges for cause.
None for cause, thank you.
People peremptory challenge.
We have no objection to anyone here, Your Honor.
All right. Defense peremptory challenge.
If I could just have one moment, please.
Yes, sir.
Sorry, Judge.
No, it's fine.
Your Honor, we're satisfied with this jury.
We have a jury, ladies and gentlemen. Ladies and gentlemen, you are our jury, and this case is set to be heard November 13th. We will give you a card. November 13th at 9 o'clock. If you could show up a little bit before 9 o'clock to the courthouse, that would be great. But we will look to start around 9 o'clock on that day. Okay? Thank you. So you got the card.
I have it.
Mr. Allen. Okay. All right. So that you understand how this works, they'll be excused. These folks will be excused. They're not going back into the pool. Okay. Well, I was about to say something that was going to make the 7 of you happy, but I can't. We usually do 1 day, 1 trial for each juror. Because of the number of trials that are projected to be selected today, we have to put you back into the pool. So everybody will be going back down and has the chance of being selected again. All right? Sorry. If it were up to me, I wouldn't do it this way, but it's not up to me. Actually, it's because of the limited number of jurors and the number of trials that we have. Okay? So as soon as Ms. Weidling puts you all back in, you will go back down. Although don't blame it on me. I only had 1 to select. So everybody else's fault. But I also should say to the 7 of you that if it looks like it's going to be a hardship to sit on another one, you can let one of my colleagues let them know that. And they'll do what they can, I'm sure. Oh, I didn't know it was going to get done today. Everybody was waiting. No, I'm kidding. All right. Folks, thank you very much. You may go back there, and Miss Weidling will take you back down to the jury room, and we'll see you guys on the 13th. Yeah.
Everything is still on.
Okay, I'll watch what I say. Thank you. Any objections to the instructions that's given by the court?
Oh, Your Honor.
No, Your Honor,
All right, very good. Anything additional?
not from us.
All right, fantastic. We will see each of you on the 13th, if not before.
Thank you, Judge.
All right, thank you.
Like us to leave these on the table?
Yes, you can leave them on the table. We'll get them, or you can hand them to Mr. Allen and he'll take them. Thank you.
Luck finding some new prosecutors.
We can set them with Ann, because I think they,
Want a job, right?
You can
Get
say.
some courtroom experience. I wonder if less and less people want to do courtroom. Want to be, in their housework.
You could be. All right, okay.
Yeah, all right, take care.
You too.